my middle name.
Perfect.
Okay, so I think the entities will be entering the room soon, and then we can, Elena, you can start.
Okay, yeah. I just want to let everyone in for 1 minute and then we can start the webinar. Just 1 quick minute so everybody can come through the Zoom. I think we can start. Good afternoon, ladies and gentlemen. On behalf of the Brazil Industry and Commerce Chamber in São Paulo, we thank you all for your presence, and I'm glad to announce and introduce our speakers for this webinar. This webinar's name and theme is US, Europe, and Latin Framework for Notifications Obligations. We count on the contribution for Cristiane, that is a senior counsel in Rio de Janeiro's office from Mayor Brown, with over 20 years of experience in intellectual property. Anna Bruder is a senior associate in Mayor Brown's Frankfurt office and an active member of the global cybersecurity and data privacy practice. Arsen Carisian is a partner in Mayor Brown Los Angeles office and also a member of the cybersecurity and data privacy practice. And Dominic Shelton Leipzig is a partner in Mayor Brown Los Angeles office and also a member for the cybersecurity and data privacy practice. I'll let the speakers talk about themselves more on their presentation, and feel free to ask any questions that may come on our chat or on the Q&A sessions. The speakers will be glad to respond them. No further ado, I would like to give the floor to Dominic to start the presentation. Just 1 quick second. Here. Please, Dominic.
Thank you so much for that warm welcome, Helena, and so happy for all of you to participate with us. Let's go to the next slide. We wanted to just be sure to cover some key things in this conversation. First, we're going to cover an overview just so we can situate breach notification laws more broadly, and also the issues of cyber and data security. Then we're going to go into the specifics on data breach notification laws, and my colleagues will discuss Europe, United States, and Latam with Cristiane taking us at the end. All right, next slide. So to provide the overview, I just wanted to make sure that we all are using the same terminology. So a security incident means any suspected or confirmed adverse event where there is a compromise of the confidentiality, integrity, or the availability of particular, in most countries, personal data. So that means either unauthorized access or exfiltration, destruction, loss, leakage of data, modification of the, changing of the data itself by a threat actor. Next slide. So in terms of where this all falls into in terms of the legal requirements for a company, there are regulatory requirements to notify both regulators and also some legislative requirements to notify consumers. And you've got vendors sometimes contractually where you have obligations to notify. And then, as I mentioned, we started out, there are a number of laws all across the globe on the issue of data breach notification. I think we were counting the other day, there's over 160 countries with data protection laws around the world, and many of those incorporate some discussion about data breach and notification. Next slide. So in terms of the data breach notification laws, so many of the laws do require individual folks, the persons whose data has been compromised, to be notified, as well as the regulators. Next slide. All right, so just to provide a quick overview, over 50% of companies have suffered one or more cyber attacks. There have been $43 billion stolen from companies. And I want to just add another stat that's not on here, that last year, data breaches cost our global economy over $6 trillion. So put another way, if data breach were a country, it would be and the losses, the 6 trillion in losses were instead market cap, it would be the third largest country in the world, just behind United States and China. And so 6.1 trillion is a significant number. And then 93% of these criminals are continuing to penetrate our systems. All right, next slide. So the average time to identify and know when a breach is occurring, 277 days. So you might have threat actors and criminals sitting in your company's systems for months, sort of looking at the landscape, figuring out who the key threat actors are, and key administrative folks are, so that they can find a way to get those administrative credentials, which are sort of the crown jewels. The cost of a data breach is over $4 million for each company hit. But as I said, globally, we're talking about 6.1 trillion last year. Next slide. So I just want to point out that this issue, because of the bottom line that I was mentioning earlier, in terms of the trillions of dollars that has impacted companies and their revenue, this has risen to be a board level issue. And so the things that boards can do to be able to, let me just back up, many regulators, stock exchanges, and right now in the US, we have a number of shareholder derivative actions that have been filed focused on accountability for CEOs and boards as it relates to data breach. In Europe, I know Anna will talk to you about some new developments we have there with the Draft AI Act, as well as DORA for financial institutions. So the things that you might be called upon to do as privacy professionals or as legal professionals is to counsel the board as to exposures. And first, that means figuring out whether there's adequate privacy and cyber alignment, whether the company has figured out what their data strategy is and what data they need to be able to execute. And once they know what data is needed, then it's a question of figuring out what governance needs to be in place. And that might mean getting rid of data that's not mission critical to the business, and then figuring out how to protect the rest. The other thing that we are highly encouraging is that when you have these conversations with the board that may not be technical experts or chief technologists, is to really contextualize the risk for them. And that means identifying what data is being collected, what mitigation is in place, and then coming to the board with a financial assessment. And we often work with separate financial assessment experts that will help us say, okay, this company is processing this many terabytes of data, they have this mitigation in place, and their exposure is 80 million euro or $80 million, et cetera, so that the board can properly assess what kind of risk they're taking on. And then you want to make sure that the board is regularly trained. The folks on here have conducted board trainings, and then make the board or help the board and the CEO look at the big picture in terms of what do the data practices in terms of protection mean for the brand's reputation for trust and value and integrity. And with that, I'm going to turn it over, I think, unless I have another slide here, to our colleagues. Okay, next slide.
Oh, that's me. Hi, everybody. So as a Brazilian who has been living in Germany for 10 years, it is a huge pleasure to be with you today. I don't know who's watching actually, but I imagine a few Brazilians and a few Germans. So really exciting. Thank you so much to AHK for organizing this. So let's talk a little bit about European data breach notification laws. We just picked a few here that are relevant to cybersecurity and data privacy in particular in the context of a breach or a cyber incident. So the first one here, the first column, is of course the GDPR, which applies in the EU and in the UK. It covers personal data, which is any information relating to an individual, and it applies to both controllers and processors. So the question is, what is the trigger for a notification obligation under the GDPR? And the answer to that is, it is a notifiable personal data breach. We'll talk a little bit more about that in the following slides. But if you have that, you need to notify the supervisory authority, or we call them DPAs, data protection authorities, without undue delay and where feasible within 72 hours of awareness. And in certain cases, you also need to notify the data subject, that is the persons that are affected, whose data is affected, also without undue delay. And it is an obligation to do the notification if these requirements are, if you have a notifiable personal data breach, and if you fail to fulfill this obligation, that is a violation of the GDPR itself. And the penalty for that is up to 4% of the worldwide turnover of the previous financial year, or 20 million euros, whatever is higher. So we'll talk a little bit more about the GDPR, but it is definitely the most relevant piece of legislation when the breach occurs and where personal data is affected. I put some more pieces of legislation in here just to give you a broader picture. So the second column here is the EU Payment Service Directive 2, and it applies to payments data that is processed by payment service providers. So what triggers the notification obligation in this case is any major operational or security incident. And also here, you need to notify without undue delay the competent authority. For example, in the UK, that would be the FTA. There's not a limited amount of penalty, but there are penalties that are foreseen if you do not fulfill a notification obligation. Then the third column here, regulations applying to the financial sector, to financial service providers, for example, in the UK. And here also the trigger for our notification obligation, material cyber incidents or with serious regulatory impact. You need to notify immediately the competent authority, which in this case, for example, in the UK would be the FTA or the PRA, depending on the case. And then on the last column here is another piece of legislation that is a bit more general regarding the sectors that are in scope, but it's not a horizontal, cross-sector piece of legislation. That's the NIS directive. NIS means Network and Information Systems Directive. Basically, this is a piece of legislation that only applies to operators of essential services, such as transportation, water, energy, and a few others, some in the financial sector as well. And also it applies to certain relevant digital service providers. So if your company is an operator of essential services, usually you should know that before the breach, so that you know when a breach occurs, whether you have any notification obligations under the NIS directive and the implementing laws, because it's a directive. It needs to be implemented into each national law of the EU member states. And it has actually been transposed quite differently between the member states. And in many, that's a very interesting piece of information that few people know in my experience. You usually are notified by an authority if you are an OES, an operator of essential services, which should make the job easier of assessing your potential notification obligations. Anyway, if you do have a security incident that has an impact, that is a significant impact on the provision of the essential service, then you need to notify. Or if you are actually a digital service provider, any incident, without undue delay again, and the competent authority depends on the EU member state. What I have learned in my experience is that it's actually a high bar to attain for you to have a notification obligation under NIS directive and the implementing laws, but it does apply if you are an OES and you have a major impact. Like, let me try to make this a bit more plastic. If you are a provider of transportation, railway transportation, and because of a cyber attack, all your systems are down and your trains cannot run, cannot provide the services, transportation services, because of the cyber attack, that would definitely be an incident having significant impact on the essential service that you would need to notify. If we could go to the next slide, please. I wanted to focus a tiny bit on the GDPR, just to put everything together. What are the elements that need to exist for you to have a notification obligation under the GDPR? So basically, you need a security incident, as Dominique also put in the beginning of this presentation. This security incident needs to lead to accidental or unlawful destruction, loss, alteration, unauthorized disclosure of, or access to personal data. Personal data, as I mentioned, is a very broad definition, as you probably are all aware. Any information relating to an identified or identifiable person. And this is important. The data needs to be subject to the GDPR for you to have a notification obligation under the GDPR, right? So let me just open a parenthesis. What does that mean? How do you know what data is subject to the GDPR? Well, you need to look into Article 3 GDPR, which are the reasons of applicability, the cases of applicability. So, for example, any data processing in the context of an establishment in the EU is subject to the GDPR. Let's say you were a global group, which is very often the case of our clients. You have a few of the subsidiaries in Europe, they have employees. So if the data of those employees of the EU establishment is affected by the breach, then that will be considered data processing in the context of a new establishment that will be subject to the GDPR. That's actually the easiest to assess, right? Because it's just, if it's an employee in the EU, then you know. The two other cases are more difficult. That is, if you are processing, so if the data that is affected by the breach refers to a person, and this person, you were only processing their data because you were offering goods and services to them, and they're in the EU, then, for example, a B2C company, right? Then you are also subject to the GDPR. And then regardless of where you are, where your company is, and which entity was processing that data, could be the US entity processing that data, for instance. And then the third case is data processing in the context of monitoring of individuals in the EU. And that in the GDPR, this monitoring is very much connected to tracking, for example, online. So if you have all this, you know you're subject to the GDPR, and you fulfill all the requirements I said before. There is one last element, the very last bullet on the first part here of the slide. You only have a notifiable personal data breach if this breach is likely to lead to a risk or a high risk to the data subject, to the affected individual. And that's very important because you may have a personal data breach that doesn't lead to risk, depending on the circumstances, depending on the data and on the data set that is affected. So if we could go to the next slide, please. What I'm saying basically is you need to do a risk assessment from the perspective of the affected individuals. So if you come to the conclusion that this breach is unlikely to result in a risk, you actually don't have any notification obligations under the GDPR. That's Article 33 GDPR. If you come to the conclusion that the breach is likely to result in a risk, then you need to notify the DPA or the supervisory authority. And if it is likely to result in a high risk, let's say you have health data in there, sexual orientation data, or because of the volume of data, you know, you have everything about this individual, that could lead to a high risk of identity theft, for instance, or other risks actually, then you need to notify both the DPA and the data subject. One bullet that I put in here that I think is very practical and very always comes up when a breach occurs is, when am I aware of a personal data breach? Because awareness is what triggers your notification obligation. You know, those 72 hours where feasible, that's as of awareness. So when are you aware? There is some guidance from the European Data Protection Board about that, saying awareness means a reasonable degree of certainty that you have a notifiable personal data breach. So very case by case specific as to what time are you aware. I would say general advice here, better err in the side of caution if you're not so sure, because you know, otherwise you might run into the risk that later on they will say, why didn't you notify you when you were aware? So, but that's also case by case to assess. Right, and then the timeline we already discussed briefly. So to the DPA without a delay were feasible within 72 hours. Also, a tiny note on the practice, I have had to do a bit delayed notifications, meaning after the 72 hours, for example, because we were assessing whether the data was subject to the GDPR or not. And it went well. We just explained the reasons. That's what the GDPR says. If you can't do it in 72 hours, you just explain the reasons. So of course you shouldn't take 3 weeks and then say, oh, I was assessing. But if you have, very founded, reasonable explanations, it does say where feasible within 72 hours. Right, and individuals also without undue delay, that's a bit more supple depending on the case. Next slide, please. Right, here I just wanted to very briefly talk about some cybersecurity framework legislation in the EU. What you are seeing in orange is what we already have. So we have the Cybersecurity Act that is the basis for ENISA. ENISA is the European Cybersecurity Agency, and it is also the legal basis for the certification schemes that can be used by companies who will be able to be used when they exist. There aren't any really concluded yet. But you will be able to use those to say, I am cyber compliant. My product or your product complies with cybersecurity requirements, industry standards, for example. The second thing you see here is the NIS directive, which we already talked about a little bit. And the third one, sectoral regulations that actually already exist. So for the financial sector, we also have the radio equipment directive that applies to Wi-Fi routers, for example, and a few others. And what you're seeing in blue, that's actually the juicy part, is what's coming. So lots of things are coming. The NIS2 directive, so it's going to amend the NIS directive, and it will extend it basically. Now it won't apply only to essential entities, essential service providers, also to important entities. So the scope is broader now. It will apply, for example, to food. In certain cases, food management will apply to space sector, and a few others. It will contain, just like the current NIS directive, cybersecurity requirements, notification obligations, and one thing that will be new in the NIS2 is you will have an obligation, if you fall under its scope, to assess supply chain. So whenever you use a vendor, you need to make sure that their cybersecurity practices are good, are appropriate, that the IT security measures are sufficient, are appropriate to the risk. Otherwise, you are actually accountable for that. Then we have DORA. DORA is the Digital Operational Resilience Act that will apply in the financial sector and a few, covering actually a lot of different aspects. And it will apply to will contain the cybersecurity requirements and also new incident reporting obligations. They go beyond what we currently have for the financial sector. One thing that is key at DORA is ICT means information and communications technology. If you fall under DORA, you will need to assess all vendors that you use, ICT vendors, and make sure, similar to NIS2 actually, that the cyber practices are appropriate and sufficient. Otherwise, you are accountable for that. And then the third one here is the Cyber Resilience Act. It's also still in draft form. This will be a bit of a revolution, I'm going to say, because it will be horizontal, streamlined cybersecurity requirements, meaning they will apply throughout as soon as you are offering digital products or ancillary services. And one thing that's important, what we currently have, these sectoral regulations, they don't cover, for example, only a software, a standalone software, right? Non-embedded software. And this will, Cyber Resilience Act will apply to non-embedded software, for example. So it will apply really to a lot of companies. And it also contains cybersecurity requirements and incident reporting obligations that are very short, something like 24 hours to report to ENISA if a digital product that you offer has an issue, a cyber issue. Next slide, please. Yeah, and then I just put this in here because I wanted to explore a little bit further on a thought that Dominique mentioned in the very beginning, that this is a board issue. So cybersecurity and privacy compliance are a board issue, and also in the context of a breach, obviously. So the NIS2 directive very interestingly says that managing bodies of essential and important entities will have to approve the cybersecurity risk management measures. They will need to follow specific training so that they're able to understand what this is all about, to really appreciate the cyber risk. And they need to be accountable for any non-compliance. Next slide, please. And then similarly at DORA, we also have a provision there in parallel saying that the managing bodies will need to define, approve, oversee, and be accountable for the implementation of the information and communications technology risk management framework. So, you know, this vendor due diligence that will be used for ICT vendors. The managing bodies are directly responsible to oversee everything, to see who's doing what are the roles, what are the responsibilities, to approve processes. They will need to follow trainings as well so that they're able to understand and be accountable. So very similar, actually, very parallel to the NIS2 directive. I guess that was it. That's what I had to say on Europe. I'm very happy to take on any questions that you might have. Otherwise, I would call my dear colleague Arsen to talk a little bit more about the US.
Great, thanks, Sandra. And if you can move on to the next slide. So unlike Europe, where the GDPR, which is the comprehensive privacy law, addresses data breach circumstances, in the United States, we do have a patchwork of comprehensive privacy laws as well that are similar to the GDPR, but these comprehensive privacy laws actually don't regulate what you're supposed to do during the data breach incident. But in particular with California's laws, California Consumer Privacy Act, the CCPA, and the California Privacy Rights Act, the one thing to note about data breaches here is that if there is a data breach and it meets the criteria for a breach under California's law, there is in fact a private right of action. So the company could face a lawsuit directly under these two statutes if there is a data breach and there are no reasonable safeguards to protect the information. The other state laws, similar to California, also merely regulate how to handle personal information from a data privacy perspective, such as, you know, transparency and data subject rights, among other things. Next slide. So in the US landscape, though, data breach notification obligations are mostly regulated on a state law level. There are some federal laws that regulate certain sectors, such as HIPAA for healthcare related data and data breaches and the notification obligations there. There's some financial regulations related to providing notice to your financial regulator when there is a data breach. But primarily every state has its own state version of data breach notification law that you have to abide by and provide notice under during any given security incident. There's also some corporate filing obligations if you do suffer a security incident that I'm going to cover. And then also, just lastly, on a broader level, the Federal Trade Commission may enforce under its UDAP statute, which is the Unfair and Deceptive Practices Act, if there is a data breach and you either fail to timely report the incident or incorrectly reported the incident to data subjects and regulators. Next slide. So as I mentioned, one slide, yeah, right there. So as I mentioned, all the states have data breach notification laws, including the District of Columbia. And, you know, some of the common things with these laws is whenever there's a security incident, all of these laws are similar in some sense in that the way they're structured is there's very specific types of personal information that has to be compromised in order for you to give a breach notice. So it's a bit different than the GDPR, where you do an assessment of is there personal data, which is a very broad term, and then you try to see if there's a likelihood of potential harm to the person in deciding whether to give notice. The US is different in that when there is a security incident, first you check whether were these very specific types of personal information impacted. And most often it's somebody's first name or first initial, last name, and then certain very sensitive or specific types of data sets, such as a social security number or financial account information or health data or other things like that. And it's only when those very specific types of personal information are in fact triggered that there is an obligation to give notice to a data subject. Another thing you have to also assess is whether you need to give notice to the state attorney general's office. And so the standard for this varies from state to state. In some states, if there is, for example, 500 persons or residents information involved, in some states it's 250, in other states there is no volume level before you have to give notice. You have to make that assessment in order to determine whether you have to give notice to the state AG's office. Next slide. And just to give you an example of one state's data breach notification law, in California, for example, if there was a security incident, and let's say multiple states were involved, the first thing you would do is you try to see in what states do these residents live whose information was compromised. And then, so for example, let's say you found out that there are about 200 California residents' personal information involved. The next thing you need to do is you need to understand what categories of personal information were triggered in order to do an assessment of whether you need to give notice. So if we look at California's law on the right-hand column, you would need to have the person's either first name or first initial and the last name, and in combination with one of these types of data sets, such as social security number, driver's license number, an account or credit card number, medical information, health insurance information, or driver's license data or biometric information. Also, if you had the username or email address of a person in combination with a password or security question to get access to the account, that would be also another triggering criteria. And so let's say you found out there were California residents involved and the first name, last name, and one of these types of data sets were involved, then now you know that you may have to give notice. And so the next question you have to understand is, or evaluate, is whether, in addition to giving notice to the individuals whose data was compromised, do I need to give notice to the state regulator, which is the California Attorney General? And so, for example, in California, if 200 persons' information was compromised, you wouldn't have to give notice to the California Attorney General, because the standard is that you need to have more than 500 California residents' information involved in order to give notice to the California Attorney General. Also, unlike the GDPR, which has a pretty quick turnaround for giving notice, which is 72 hours, California, for example, doesn't have a very specific deadline. Rather, you just have to give notice in the most expedient time possible and without unreasonable delay. That's actually the standard for most of the states in the United States, although some states like Colorado, Florida, Maine, and Washington have like a 30-day requirement for giving notice. And so basically, anytime there's a suspected data security incident, the one thing that we always do is fully map out the types of personal information involved in the US, which states are involved, in order to assess state by state what would be the notification obligation. Next slide. Another thing to factor in, if you're a publicly traded company and you do filings with the Securities and Exchange Commission, it's important to consider whether, in light of a security incident, a material cybersecurity incident, your obligations to report that as part of your public filings in a Form 8K. In order to determine whether it's a material security incident, these are some of the factors considered, such as whether there could be significant loss or reduced revenue, if it appears connected to a change in a stock price, if you might get significant media coverage, whether it could impact your business, among other things. And so after a potential security incident, if you're representing a publicly traded company, it's important to also talk to your corporate attorneys who handle some of these SEC filings in order to ensure that you're complying with that obligation as well. Next slide. Another thing to consider is just your general obligations to not engage in unfair or deceptive practices act. Now, when you do suffer a security incident, you could potentially face an enforcement action by the Federal Trade Commission under that Unfair and Deceptive Practices Act prong of its statute, if you fail to disclose information to individuals that could potentially harm them following a data security incident, or if you did give a notice, but the notice itself was misleading because it omitted certain information or it misled the individuals about what exactly happened. And sort of tied to this also is Dominic talked about board and C-suite issues. Companies should be aware that internally in the company, there should be briefing about security incidents as well, because if you don't fail to act in a timely manner as the officer or director of a company, or if you make representations that are not truthful on behalf of your company, you could actually face personal liability, whether in the form of derivative lawsuits or class action lawsuits, where officers and directors are personally held liable for failing to have internal controls in the company to truthfully report incidents or to timely report incidents following a data privacy and security incident. Next slide. And with that, I'll turn it over to my colleague, Chris, who will cover the Latam environment.
Thank you, Arsen. So we will all now land in Latam. As you all can imagine, we have in Latam lots and different privacy laws and best practice. So besides Brazil, that we will cover separately today, we selected 4 other jurisdictions to bring an overview of cyber incident requirements in Latam. So Mexico, Colombia, Argentina, and Chile. Well, this chart that you were seeing covers the main topics related to incident requirements in Mexico, Colombia, Argentina, and Chile. I will cover these topics in 2 blocks. So the first block, I will cover which are the triggers for notification. Is it mandatory to notify, and who to notify? So for those who are following the chart, please refer to lines 3, 4, and 6. And so in Mexico, it's mandatory for the controller to notify the data subjects when cyber incidents significantly affect their moral or material rights. Not mandatory, but highly recommended as a best practice, the controller should also notify the INAI, Mexican authority. For Colombia, controllers or processors must notify the CDPA, Colombian authority, and the data subjects of any incident. In Argentina, it's really the opposite of Mexico and Colombia. There is no obligation in reporting any cyber incident. However, it's highly recommended to notify AAPI, Argentinian local authority, and the subjects affected. I highlight that either in Argentina or Colombia, any level of incident is notifiable. Well, to close this block, in Chile, there is, just one second, there is a very, I'm sorry, just one second. In Chile, there is no current obligation to notify any cyber incident. To be noted that there is a Chilean data protection bill to be approved that establishes mandatory notifications and creates the Chilean authority. So let's keep our eyes on it, okay? For the second block, I will cover with whom falls the notification of obligation and the timing to notify. In both Argentinian and Chilean jurisdictions, it's not clear in the law nor any resolution with whom falls the notification obligation. So it can fall upon both controllers and processors. In Mexico, as mentioned, the notification obligation falls upon controllers. In Colombia, it can be controller or processor, depending on who have registered the affected database at the National Databases Registry. For Chile, the mentioned data protection bill states that the notification obligation is for the controller and the processor. But again, we should monitor this bill because things can change in the future. As of timeline, we can say that it's mandatory to notify in Mexico, but solely the data subjects affected without undue delay. In Colombia, the deadline to report to CDPA and data subject is 15 days counted from the date the controller or processor become aware of the incident. Ultimately, as opposed to Mexico and Colombia, Argentinian and Chilean laws do not mention any deadline. Next slide, please. So now let's jump into Brazil framework. Next slide, please. According to the LGPD enacted in 2018, data controllers must notify the ANPD, which is the Brazilian Data Protection Supervisory Authority, and the data subjects only when any information security incident leads to any risk or to relevant damage to the individuals affected. And this immediately raises up two questions. What is to be considered as a notifiable risk? What should be understood as a relevant damage? We do not have complete answers from ANPD so far. Next slide, please. So this being said, before reporting any cyber incident to data subject, a risk assessment must be performed to evaluate the risk and damage to said individuals. This risk assessment shall consider some circumstances, as for example, if it involves sensitive data, personal data, or vulnerable categories of data subjects, if it impacts on data subjects' reputation and honor, amount of data involved, also geographic extension of the incident. So I brought a list here that is not non-exhaustive. So it's just a circumstance that should be taken into consideration while evaluating the risk involved. So next slide, please. As previously mentioned, controller must report the Brazilian Data Protection Authority, data subjects, of course, depending on the result of this risk assessment that I just mentioned, and sectoral regulators. Notifying the ANPD is mandatory for any organization, regardless of the market, the industry, in 2 business days. To be noted that this deadline, 2 business days, still can be reviewed by the ANPD. So next slide, please. Well, in Brazil, there are some other sectorial authorities that require a specific notice to be addressed to them when a cyber incident happens. To be noted that companies do not need to make any risk assessment regarding the impacts on the data subjects. So as long as the sectorial authorities determine the factor that triggers the notification, the company shall proceed accordingly. We will start with the CVM, which is the Brazilian Securities and Exchange Commission. So I just in a broad analysis here, CVM requires a notice from any company publicly traded in Brazil who understands that any incident is a relevant factor for them. CVM also requires a notice from intermediaries, that is, from the institutions qualified to act as a member of the distribution system in the negotiation of securities in regulated securities markets. CVM triggers for reporting are incidents that affect critical business processes, incidents that involve sensitive data or information, and incidents that significantly impact on customers within the market. Currently, there is no specific deadline to notify CVM. So next slide, please. So in this slide, we will cover the sectoral authorities, Bacen, Anatel, and ANEEL. Let's start for Bacen, which is the Brazilian Central Bank. We draw your attention to the following. In case of a cyber incident, all institutions authorized by the Brazilian Central Bank must notify Bacen. For the purposes of Bacen, an incident is understood as any unauthorized, accidental, or illicit access that may lead to destruction, loss, alteration, leakage, fraud, or any form of inappropriate or illicit data processing, exposing the rights and freedoms of the affected personal data subjects and the institution to risk. Here, there is also no specific deadline to report to Bacen. Now we're gonna move forward to Anatel, which is the Brazilian telecommunications agency. All telecommunication service providers of collective interest, except the small-sized ones, as indicated by Anatel's regulation, must notify Anatel when any cyber incident happens. Once again, there is no specific deadline. And additionally, the thresholds are very similar to CVM's major incidents that substantially affect the security of the telecommunication networks and users' data. So last but not least, we will talk about ANEEL, which is the Brazilian Electric Energy Agency. Here, the obligation to notify falls upon any company authorized by ANEEL to conduct activities related to electric power services or facilities, entities responsible for the system's operation, for the commercialization of electric power or management of resources resulting from sectorial charges. Reporting is necessary for major cyber incidents that substantially affects the security of facilities, operation, or user or data services defined according to the severity classification established by the company. Much alike CVM's and Anatel's triggers, the agency does not indicate a specific deadline, but requires that the report be sent once the entity is aware of the incident and its extent. So I would like to thank you all for listening to us. It was really a pleasure for all of us to run through cyber incident requirements in US, Europe, and Latam. As you may see, we had a lot to cover. So I just wanted to highlight what Anna said. Feel free to address questions to us. And with that in mind, I will turn over to Brazil Chamber. I think it's Elena, right, Elena?
Yes, I would like to thank you all for the excellent explanations and presentations. It was very, very helpful. I can say that, and very explainable for all of us. I would like to know if there's any direct questions. Where not, I have one. Anna, please feel free.
I'm so sorry, that was actually a mistake, guys. But
okay, no problem at all. No problem at all.
That's really great.
No problem at all. I want to know. I don't know who would like to answer that. In your opinion, what's the most vulnerable point in the companies from data privacy? It's like a systemic problem, like the systemics are not secure enough, or something else? It's a really big question in my mind. I would like to share with you. I don't know if you have any inputs.
I'm not sure I understand the question, Elena. Do you mean what is the biggest vulnerability of companies?
Yeah, yes. Sorry.
Sure. Well, I'm curious to hear about Arsen and Cristiane, what they think. But in my view, I think it's just a huge challenge for companies to be compliant with privacy and cyber requirements. A breach is really a situation where it's a very, very stressful situation, because not only you need to be compliant in general, but also in this specific situation, there are specific obligations that arise, these notification obligations, right? And the risk is not only not doing the notification part right, but also what might come out when you do the notification obligations if there's an investigation, for instance. So I think the whole, like the event, the cyber attack or the cyber incident is, of course, in itself a huge vulnerability, but it's also just the top of the iceberg, so to speak, of everything that the company was actually meant to have been compliant with all along, and potentially is not.
Yes, and I would just add also, Anna, the best practice, right? Because we should all look not only for the laws and regulations, but also to the best practice of certain jurisdictions. And so there are so many difference between jurisdictions. So we need to, when there is indeed a incident, cybersecurity incident that affects several jurisdictions, we really have to care about all this.
Yeah, and I think the one thing I'll say about that is, I think it's two issues about the vulnerability of our company. One is like external bad actors that, you know, the way to protect against that is to ensure your cybersecurity mechanisms are adequate and reasonable. So you would do various audits just to check that. But then on another front, which is something that's more in your control, is employee error. Sometimes it happens where somebody will have some customer Excel document that has a list of customers and other personal information. They might inadvertently email it to the wrong person or outside the organization. And so some of these, I think, they can be mitigated by just having good training in the company about good email practices or best practices of handling data, and also implementing what is called the rule of least privilege, which is don't let everybody have access to sensitive forms of data in your system. Only those that actually have a business need to access a customer list or access employees' health data for benefits purposes or whatever the case might be, just to have effective controls like that in place. And I think that's one way you can at least have some control of your company. But the thing with data breaches is it's not if it'll happen to you, it's when it'll happen to you. And so if it does happen, when it does happen, you have to also make sure you have a effective incident response plan within the company so that you know what you're going to do the moment that incident happens.
Perfect. Yeah, for me, it's very clear. Yeah, I agree with you all. I think that's a very sensitive question. And I have another question. You mentioned email practice, and I think Dominic talked a little about the board training, and I think that's a really good point. And I think I would like to hear the input from you. Which periodicity, how can I say that? Like, how many times a year or month do you think the company must have a board training or something like that?
Well, I think for board level, we do recommend at a minimum to have somebody from privacy brief the board and C-suite at least once a year. Ideally, it'll be on a quarterly basis during the audit committee hearings. So anything between 1 and 4 is good. I mean, the more you have it, the better. I think especially with companies that are very data heavy, it's critical to have it at least twice a year or 4 times a year, and make it a regular routine. It could be something as simple as 15 minutes as part of the agenda item, but it's important that board and C-suite be involved and reflect in the minutes of the company that there was direction and discussion regarding data privacy and security issues.
Yeah, and if I may add to that, I completely agree with you, Arsen. One thing that a trend that we have been seeing is that sometimes the company's CISO, the Chief Information Security Officer, is actually sitting in the board. I've seen this before. Or you have another board member that is a cyber expert. So for companies that are data driven, that have, well, every company is a data company, as Dominique would say, but depending on the specificities of the company, it's even more important that you have somebody in there that not only needs training, but is already an expert in this area.
Yeah, I agree. Chris, do you want to add something? Sorry, Ed. I don't know.
No, I think Arsen and Anna cover all.
Perfect.
Nothing to add at this point. I'm curious about if there is anyone that have questions in the audience. I saw that Anna mentioned that we also speak Portuguese, so if anyone wants to raise a question in Portuguese, feel free.
Yes, I want to say also in Português. Fiquem à vontade de mandar no chat as perguntas, mas caso não tenha, a gente vai se encaminhando por encerramento.
Great. Thank you all very much. It was great talking to you.
Yeah, it was pretty much. Thank you very much, and we'll keep in touch and feel free to contact our speakers. The contacts from them will be on the presentation, and have a nice afternoon for you all.
Thank you again.
Thank you.
Thank you.
Bye.
Bye.
Bye bye.